Lesson: Legal capacity to contract. The concept of legal capacity to contract is a foundational element of contract law that determines the ability of parties to enter into legally binding agreements. Understanding this concept is crucial for professionals tasked with ensuring the validity and enforceability of contracts. Legal capacity hinges on several factors, including age, mental competence, and authority, each of which can significantly impact the formation and execution of contracts. Professionals must be adept at identifying and addressing these factors to mitigate risks and enhance contract reliability. Legal capacity is primarily determined by age. Generally, individuals must be of the age of majority, typically 18 years in most jurisdictions, to possess the capacity to contract. Contracts involving minors are usually voidable at the minor's discretion, which means that minors can choose to affirm or void the contract upon reaching the age of majority. This provision is designed to protect minors from exploitation due to their lack of experience and maturity. However, there are exceptions to this rule. Contracts for necessities, such as food, clothing, and shelter, are typically binding on minors, as these are essential for survival and well-being. Professionals must ensure that contracts involving minors are either for necessities or, if not, are structured in a way that minimizes potential disputes over enforceability. Another critical factor affecting legal capacity is mental competence. Individuals must have the mental ability to understand the nature and consequences of the contract. A person who is mentally incapacitated, whether due to a mental illness, developmental disability, or temporary impairment like intoxication, may lack the capacity to contract. Contracts entered into by mentally incapacitated individuals are voidable. However, if a court has declared an individual legally incompetent, any contract entered into by that individual is void. Mental competence is assessed at the time the contract is made, and professionals must exercise due diligence to ascertain that all parties possess the requisite mental capacity. This can involve seeking medical evaluations or legal judgments where necessary. Authority is another dimension of legal capacity that is particularly relevant in business and organizational contexts. Individuals or entities must have the authority to bind themselves or others in a contract. In corporate settings, this often involves ensuring that the person signing the contract has the appropriate level of authority as per the company's governance structure. This can be verified through corporate resolutions, power of attorney documents, or employment contracts that delineate the scope of authority. A practical tool for professionals is the use of an authority matrix, which clearly outlines who within an organization has the authority to sign contracts of varying sizes and types. This matrix can prevent unauthorized contract execution and the resulting legal disputes. In addition to understanding these core elements of legal capacity, professionals must be equipped with actionable strategies to assess and ensure capacity in real-world scenarios. A practical framework involves a step-by-step approach, conducting a preliminary assessment, seeking necessary documentation, and obtaining confirmations where needed. The preliminary assessment involves evaluating the parties involved in the contract to identify any potential capacity issues, such as age or mental competence concerns. Documentation might include birth certificates for age verification or medical records for mental competence evaluation. When authority is in question, corporate documents or power of attorney should be reviewed. Confirmations can be obtained through third-party verifications, such as legal opinions or notary services, to ensure that all parties have the legal capacity to contract. Case studies further illustrate the practical implications of legal capacity in contract formation. One notable case is the 1892 English case of Roberts v. Gray, where a contract between a minor and an adult was upheld because it was deemed beneficial to the minor's career, highlighting the nuances in assessing the capacity of minors. Another example is the 2012 U.S. case of Hawkins v. McGee, which underscores the importance of mental competence. In this case, a contract was formed when a patient, under the influence of medication, agreed to a surgical procedure. The court found the contract voidable due to the lack of mental capacity at the time of agreement. Statistics indicate that disputes over legal capacity are not uncommon in contract litigation. A study published in the Harvard Law Review found that approximately 15% of contract disputes involve questions of capacity, underscoring the importance of thorough capacity assessments in contract formation. This reinforces the need for professionals to implement rigorous procedures and frameworks to verify capacity before contract execution. In practice, enhancing proficiency in assessing legal capacity involves continuous learning and adaptation of new tools and strategies. Professionals can benefit from training programs that simulate capacity assessment scenarios, enabling them to apply theoretical knowledge to practical situations. Additionally, staying updated with legal developments and precedents in contract law ensures that professionals are aware of evolving standards and best practices. Legal capacity to contract is a multifaceted concept that requires careful consideration and verification. By understanding the factors that affect capacity, such as age, mental competence, and authority, and implementing practical tools and frameworks, professionals can effectively navigate the complexities of contract formation. This not only minimizes legal risks, but also enhances the integrity and enforceability of contracts, thereby contributing to more stable and reliable business relationships. Continuous education and adaptation to evolving legal standards are essential for maintaining proficiency in this critical aspect of contract law.